Great. So we divided the criminal law module into different parts. At part one, we have the criminal liability equation. At part two, we look at non-fatal offenses. At part three, we look at fatal offenses. And at part four, we look at defenses. Today, we want to zoom into part one. We want to think about the criminal liability equation. Of course, naturally, we would need to consider the parties engaged in the criminal litigation process. We have the judge, we have, if it's a trial before the Crown Court, we have jurors, we have the prosecution, we have the defense. When we think about the criminal liability equation, we are thinking about requirements that must be met by the prosecution if they wish to obtain a conviction in relation to the defendant. This criminal liability equation has different elements. The elements, they are attached to the offense in question. Normally, a criminal offense will feature what is known as the actus reus as well as the mens rea. The actus reus is the prohibited act, and the mens rea is the guilty mind. Sometimes the criminal liability equation would also include a causal element, but that depends on the nature of the offense. For example, if the offense is a result type crime, like murder, there is going to be a requirement placed at the feet of the prosecution to go beyond the actus reus and the mens rea and also satisfy the causal, also known as causation element. So let us think about the details in our part one. Here we would find the actus reus 1, 2, the mens rea, 3, causation, 4, the doctrine of transferred malice, 5, the doctrine of coincidence, and 6, strict liability offenses. We will ventilate all of those issues. We begin with the actus reus. And like I said, when we think about the actus reus, we are thinking about the prohibited act. This prohibited act may manifest in different ways. What do I mean by that? Maybe the prohibited act that's listed in the criminal offense is that a particular type of conduct is being prohibited. For example, we think about the Theft Act 1968. There at section 1, we will find the offense of theft. A person is guilty of theft where he dishonestly appropriates property belonging to another with the intention to permanently deprive the other of it. When we think about this criminal offense, i.e. theft, we can identify the actus reus element. The law prohibits a particular type of conduct. What's the type of conduct? Appropriating property belonging to another. That conduct is prohibited. That is one manifestation of the actus reus. The actus reus can also manifest in relation to result type crimes. So we think about a criminal offense like murder. We will find in the definition of murder that it is unlawful for a person to unlawfully kill a human being with the intention to kill or the intention to cause grievous bodily harm. When we think about the Actus Reus, there are three elements. When we think about the Actus Reus attached to the offense of murder, there are three elements. One, unlawful. Two, killing. Three, a human being. The question is, does the offense of murder prohibit a particular type of conduct, or does it prohibit a particular result? Think about it. Does it prohibit a particular type of conduct, or does it prohibit a particular result? We know the answer is the latter. It prohibits a particular result, in that if you unlawfully kill a person, if you unlawfully kill a human being, that result, no matter how you do it, whether you stab the person, whether you strangle the person, whether you shoot the person, however you go about doing it, whatever conduct you engaged in to bring about the result, the conduct part is not prohibited. It's the result part that is prohibited. It is the end result. It is the unlawful killing of a human being that's being prohibited in the offense of murder. It means that the Actus Reus is not limited to the prohibition of a particular type of conduct. It also includes the prohibition of a particular result. The Actus Reus also manifests in the way of what is known as state of being. State of being. And here we are making reference to offenses, criminal offenses, where the Actus Reus is articulated in relation to being in a particular state, i.e., state of affairs. So maybe you are being in possession of an illegal firearm. Maybe you are being in possession of a contraband. Are you actively doing something? Is that offense prohibiting a particular type of conduct? The answer is no. Is that offense prohibiting a particular result? The answer is no. That offense is prohibiting the individual from being in a particular state. So, when we think about the state of being or the state of affairs, usually the student may look at the criminal offense, and because they are not seeing some conduct element, or because they are not seeing some result element, they think that there is no Actus Reus. There is no Actus Reus element in the offense, and that is not correct. Why? Because the Actus Reus manifests in different ways that are not limited to conduct type crimes or result type crimes. It also includes being in a particular state. It's the state of affairs. Finally, we know that the Actus Reus also manifests as an omission. You may very well find a criminal offense that makes reference to failing to act. So maybe there is a requirement for you to do something and you do not do that thing. Maybe if you get into an accident, you are supposed to make a report to the nearest police station. Failing to do so might very well lead to you being charged with a criminal offense. In some offenses, where the individual fails to act, it may very well satisfy the Actus Reus element of the offense. Now, specifically, we are talking about omissions. And when you are studying omissions, you need to look at it carefully. Because here, the Actus Reus manifests as a failure to do something. However, generally in English law, there is no criminal liability where a person fails to do something unless what? Unless he has a duty to act. So when you are thinking about omissions, i.e., this manifestation of the Actus Reus, you want to ensure that you read it accurately. Because generally in English law, there is no criminal liability where a person fails to act. That is the rule at the outset. Unless he has a duty to act. So maybe you are under particular duty to act and you fail to act. For example, maybe you are a lifeguard. The lifeguard is under a contractual obligation to act. Why? Because the lifeguard is on shift, let us say, from 8 a.m. to 4 p.m. By virtue of his contract, he is compelled to act during that period of time. Let's say that at 5 p.m., so he's been off for an hour. Let's say at 5 p.m., someone gets into some difficulty and the attendees at the beach, they begin to scream, help, help. Morally, you would expect that lifeguard, despite the fact that he is off the clock, despite the fact that 4 o'clock passed an hour ago, you would still expect him to intervene because he's the one with the skill set. He is able to swim. He knows how to save lives. But legally, is he obligated to do so?